Hello and welcome to Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. Like, subscribe, and ring the notification bell so you can be updated every time we upload new content. It's our goal to upload new content every day at 8 a.m. Eastern Standard Time. Question number 1. Orderly, a male attendant who worked at hospital, had sexual relations with patient, a severely retarded person, in a room at hospital. In a tort action brought on patient's behalf against hospital, patient will A. Not prevail if orderly's actions were outside the scope of his employment. B. Not prevail if patient initiated the relationship with orderly and encouraged his actions. C. Prevail if orderly was an employee of hospital. Or D. Prevail if hospital failed to use reasonable care to protect patient from such conduct. Take 10 seconds and choose the best answer now. If you chose option D, prevail if hospital failed to use reasonable care to protect patient from such conduct, you'd be correct. The respondeat superior doctrine states that if an employee commits a tort in the scope of their employment, their employer will be vicariously liable. However, an employer is generally not vicariously liable for the intentional torts of employees unless the intentional tort involves actions specifically authorized by the employer, the nature of the employment, or acts motivated by the desire to serve the employer. Employers, however, can also be found liable for the intentional torts of their employees under a negligence theory, i.e., the employer failed to use reasonable care to protect the victim from such conduct. The nature of orderly's employment is to provide care for patients at the hospital. Instead of providing care, orderly abused his position and had sexual relations with the patient. While an employer would generally not be vicariously liable for the intentional torts of employees, hospital is ultimately responsible for exercising reasonable care to protect patient from such conduct. So while hospital is not automatically liable for the intentional tort committed by orderly, hospital will be responsible if it failed to use reasonable care to protect the patient from such conduct. Let's look at option A. Option A, not prevail if orderly's actions were outside of the scope of his employment. We can pretty much guess here that his actions were outside of the scope of his employment. I think that'd be a fair presumption. However, as noted, just because it falls outside of the scope of his employment, that in and of itself does not limit liability. B. Not prevail if patient initiated the relationship with orderly and encouraged his actions. We're told by the fact pattern that the individual is severely retarded. As a result, consent is immediately in question. C. Prevail if orderly was an employee of the hospital. The orderly being an employee in and of itself does not cause liability. For example, if orderly decided to inject his wife with insulin, although she was not diabetic, during his lunch break, although at the hospital, and she's not a patient of that hospital, killing her, I don't think that liability would ultimately rise because the individual was not actually, in fact, in the care or custody of the hospital. So here, the fact that he is an employee does not, in and of itself, grant liability. Question number 2. Jones, a marijuana farmer, had been missing for several months. The Sheriff's Department received an anonymous tip that Miller, a rival marijuana farmer, had buried Jones in a hillside about 200 yards from Miller's farmhouse. Sheriff's deputies went to Miller's farm. They cut the barbed wire that surrounded the hillside and entered, looking for the grave. They also searched the adjacent fields on Miller's farm that were within the area enclosed by the barbed wire and discovered clothing that belonged to Jones hanging on a scarecrow. Miller observed their discovery and began shooting. The deputies returned fire. Miller dashed to his pickup truck to escape. Unable to start the truck, he fled across a field toward the barn. A deputy tackled him just as he entered the barn. As Miller attempted to get up, the deputy pinned his arms behind his back. Another deputy threatened, "Tell us what you did with Jones, or we'll shut you down and you'll see your family on relief." Miller responded that he had killed Jones in a fight, but did not report the incident because he did not want authorities to enter his land and discover his marijuana crop. Instead, he buried him behind the barn. Miller was thereafter charged with murder. If Miller moves to suppress his admission about killing his neighbor, the court should A. Grant the motion, because Miller did not voluntarily waive his right to silence. B. Grant the motion because the statement was the product of the warrantless entry in search of Miller's farm. C. Deny the motion because the deputy was in hot pursuit when he questioned Miller. Or D. Deny the motion because Miller was questioned during a police emergency search. Take 10 seconds and choose the best option now. If you chose option A, you'd be correct. Grant the motion because Miller did not voluntarily waive his right to silence. To protect the suspect's Fifth Amendment right against self-incrimination, police must give Miranda warnings before interrogating a person in custody. A person is in custody if she is not objectively free to terminate the encounter with the government, that is. She does not reasonably believe that she is free to leave. An interrogation is any conduct that the police know or should know is likely to elicit an incriminating response from the suspect. Miranda warnings inform the defendant of their right to remain silent and their right to an attorney. A waiver of Miranda rights is only valid if the defendant knowingly, voluntarily, and intelligently waives them. In this case, a deputy tackled Miller and pinned his arms behind his back. At this point, Miller was in custody because he could not reasonably believe he was free to terminate this police encounter. Then another deputy threatened, "Tell us what you did with Jones, or we'll shut you down and see your family on relief." This constituted an interrogation because the deputy knew or should have known that the statement was likely to elicit an incriminating response. Since Miller was subject to a custodial interrogation, the police should have given Miller his Miranda warnings. Absent Miranda warnings, Miller could not have knowingly, voluntarily, and intelligently waived his right to silence. Therefore, the court should grant the motion to suppress because Miller did not voluntarily waive his right to silence. Let's look at option B. Grant the motion because the statement was the product of the warrantless entry in search of the Miller's farm. I think B misses the point in that while there was a warrantless entry, in essence, the individual was shooting at the police when they entered. So there was a commission of a crime, so the warrant exception may not be in fact necessary. C. Deny the motion because the deputy was in hot pursuit when he questioned Miller. While hot pursuit does grant some leeway to an officer, and it may permit warrantless entries into property, hot pursuit does not extend to questioning of a suspect. And finally, D. Deny the motion because Miller was questioned during a police emergency search. D would seemingly fit into the made-up options and would not be a proper option for an answer here. As a result, A. Grant the motion because Miller did not voluntarily waive his right to silence is the correct answer. Question number 3. A written construction contract under which contractor agreed to build a new house for owner at a fixed price of $200,000 contained the following provision. Prior to construction or during the course thereof, this contract may be modified by mutual agreement of the parties as to extras or other departures from the plans and specifications provided by owner and attached hereto. Such modifications, however, may be authorized only in writing, signed by both parties. During construction, contractor incorporated into the structure overhanging gargoyles and other extras orally requested by owner for orally agreed upon prices in addition to the contract price. Owner subsequently refused to pay anything for such extras, aggregating $30,000 at the agreed prices, solely on the ground that no written signed authorization for them was ever effected. If contractor sues owner on account of the extras, which, if any, of the following will effectively support owner's defense? 1. The parole evidence rule. 2. The pre-existing duty rule. 3. Failure of an express condition. Or 4. The statute of frauds. Look at your 4 options. Is it 1 and 3 only? 1 and 4 only? 2 and 4 only? Neither 1, 2, 3, nor 4. Choose the best option. Take 10 seconds now. If you chose option D, neither of the 4, you'd be correct. Under the common law, the rule is that contract provisions expressly prohibiting oral modification or requiring writing for such modifications are ignored. In this case, we have a valid written contract between contractor and owner for the construction of a new house with a provision requiring writing for any modifications. Under the common law, this provision would be ignored so contractor and owner could orally modify their agreement, which they did. As such, these modifications are in fact enforceable, and none of the contract law defenses listed above would change that. Question number 4. Pedestrian died from injuries caused when driver's car struck him. Executor, pedestrian's executor, sued driver for wrongful death. At trial, executor calls nurse to testify that 2 days after the accident, pedestrian said to nurse, "The car that hit me ran the red light. 15 minutes thereafter, pedestrian died." As a foundation for introducing evidence of pedestrian's statement, executor offers to the court doctor's affidavit that doctor was the intern on duty the day that the pedestrian died, and that several times that day pedestrian had said that he knew he was about to die. Is the affidavit properly considered by the court in ruling on admissibility of pedestrian's statement? A. No, because it is hearsay, not within any exception. B. No, because it is irrelevant since dying declarations cannot be used except in prosecutions for homicides. C. Yes, because though hearsay, it is a statement of then existing mental condition. Or D. Yes, because the judge may consider hearsay in ruling on preliminary questions. Take 10 seconds and choose the best option now. If you chose option D, yes, because the judge may consider hearsay in ruling on preliminary questions, you'd be correct. Under Federal Rules of Evidence 104A, the court must decide any preliminary questions about whether a witness is qualified, a privilege exists, or evidence is admissible. In so doing, the court is not bound by evidence rules, except those on privilege. The question here is about the affidavit from the doctor, which includes information that would allow the judge to determine if the pedestrian statement to the nurse would fall under the dying declaration to hearsay exception. As such, the affidavit was properly considered by the court in ruling on the admissibility of pedestrian statement. Option A would be incorrect because we are at a preliminary stage where the rules of evidence don't generally apply. B. No, because it is irrelevant since dying declarations cannot be used except in prosecutions of homicide. This is actually, in fact, inaccurate because dying declarations can also be used in civil matters. And finally, option C, yes, because though hearsay, it is a statement of then existing mental condition. Again, this is irrelevant given the fact that what we're seeking ultimately is to have the evidence introduced as a dying declaration. That would be more appropriate given the facts that the fact pattern explains that the person who made the statement was dying. Question number 5. Passenger departed on an ocean liner knowing that it would be a rough voyage due to predicted storms. The ocean liner was not equipped with the type of lifeboats required by the applicable statute. Passenger was swept overboard and drowned in a storm so heavy that even a lifeboat that conformed to the statute could not have been launched. In an action against the operator of the ocean liner brought by passenger's representative, will passenger's representative prevail? A. Yes, because the ocean liner was not equipped with the statutorily required lifeboats. B. Yes, because in these circumstances, common carriers are strictly liable. C. No, because the storm was so severe that it would have been impossible to launch a statutorily required lifeboat. Or D. No, because passenger assumed the risk by boarding the ocean liner knowing that it would be a rough voyage. Take 10 seconds. If you chose option C, you'd be correct. No, because the storm was so severe that it would have been impossible to launch a statutorily required boat. To establish a prima facie case of negligence, the plaintiff must prove 1. Duty, 2. Breach of that duty, 3. Causation, and 4. Actual damages. Actual cause requires that but for the breach of duty by the defendant, the plaintiff would have not been injured. The negligence per se doctrine applies when a safety statute has a sufficiently close application to the facts of the negligence case before the court. For negligence per se to apply, the plaintiff must be a member of the class of persons whom the statute was designed to protect, and the statute must have been intended to prevent injury against a particular type of harm suffered by the plaintiff. Under the negligence per se doctrine, an unexcused violation of a safety statute conclusively establishes duty and breach of that duty. In this case, the ocean liner was not equipped with the type of lifeboats required by the applicable statute. Clearly, the statute was designed to protect passengers on boats from drowning in an emergency, so the doctrine of negligence per se would apply. As such, the ocean liner's unexcused violation of the safety statute conclusively establishes duty and breach of that duty by the ocean liner. However, the passenger's representative must be able to show causation as well. Actual cause requires that but for the breach of the duty by ocean liner, passenger would not have drowned. The facts indicate that the storm was so heavy that even a lifeboat that conformed to the statute could not have been launched. As such, ocean liner's negligence did not cause passengers injury, so passenger's representative would not prevail in an action against the operator of the ocean liner. Question number 6. Jones, a marijuana farmer, had been missing for several months. The sheriff's department received an anonymous tip that Miller, a marijuana farmer, had buried Jones in a hillside about 200 yards from Miller's farmhouse. Sheriff's deputies went to Miller's farm. They cut the barbed wire that surrounded the hillside and entered, looking for the grave. They also searched the adjacent fields on Miller's farm that were within an area enclosed by the barbed wire and discovered clothing that belonged to Jones hanging on a scarecrow. Miller observed their discovery and began shooting. The deputies returned the fire. Miller dashed for his pickup truck to escape. Unable to start the truck, he fled across a field toward the barn. A deputy tackled him just as he entered the barn. As Miller attempted to get up, the deputy pinned his arms behind his back. Another deputy threatened, "Tell us what you did with Jones, or we'll shut you down and see your family on relief." Miller responded that he had killed Jones in a fight, but did not report the incident because he did not want authorities to enter his land and discover his marijuana crop. Instead, he buried him behind the barn. Miller was thereafter charged with murder. If Miller moves to exclude the introduction of Jones's clothing into evidence, the court should A. Grant the motion because the deputies had not obtained a warrant. B. Grant the motion because the deputies' conduct in its entirety violated Miller's right to due process of law. C. Deny the motion because Miller had no expectation of privacy in the fields around his farmhouse. Or D. Deny the motion because the clothing was not Miller's property. Take 10 seconds and choose the best answer now. If you chose C, deny the motion because Miller had no expectation of privacy in the fields around his farmhouse, you'd be correct. The Fourth Amendment prohibits unreasonable searches and seizures. Unreasonable searches and seizures are those involving state action intruding upon an individual's reasonable expectation of privacy. The purpose of the Fourth Amendment is to prevent police and law enforcement misconduct. An individual has a reasonable expectation of privacy in the immediate areas surrounding the home, but not in the open fields surrounding that home. Open fields, even if enclosed with a fence, are not protected by the Fourth Amendment. In this case, the police initially cut a barbed wire fence surrounding a hillside about 200 yards away from Miller's farmhouse to search for Jones's grave. Miller had no reasonable expectation of privacy in this open hillside because it was so far away from his home. Moreover, the barbed wire fence did not automatically create a reasonable expectation of privacy. The police then searched the adjacent fields on Miller's farm and found Jones's clothing hanging on a scarecrow. Miller still had no reasonable expectation of privacy in these adjacent open fields because they were not in the immediate area surrounding his home. While the police may have committed a tort or crime in their act of cutting the fence and entering the field, this act is not a violation of the Fourth Amendment because open fields are not given protection under the Fourth Amendment. Therefore, the court should deny Miller's motion to exclude Jones's clothing because Miller had no expectation of privacy in the fields around his farmhouse. In essence, a connection can be made here to the plain view doctrine, where if an officer sees something in plain view, ultimately there is very little argument with regards to the admissibility of that item. Let's look at the other options. Grant the motion. In A, grant the motion because the deputies had not obtained a warrant. Again, missing the point. The warrant is besides the issue, given the fact that the officers could openly see the items. B, grant the motion because the deputies' conduct in its entirety violated Miller's right to due process. As noted, this isn't in fact accurate because of the plain view idea. the officers were able to openly see in the field the items in question. And finally, D, deny the motion because the clothing was not Miller's property. The assumption here would be that the fact that it's not his property would perhaps remove him from having standing in order to challenge the items to be introduced, although given the fact that they were found on his property, one could argue that there is a presumption of possession of those items and a presumption of custody and standing to challenge the introduction of those items, especially given that they're being introduced for the purposes of prosecution against him. So as a result, D would not be accurate, and C would be the best choice. Question number 7. On April 1st, owner and buyer signed a writing in which owner, in consideration of $100 to be paid to owner by buyer, offered buyer the right to purchase Greenacre for $100,000 within 30 days. The writing further provided this offer will become effective as an option only if and when the $100 consideration is in fact paid. On April 20th, owner, having received no payment or other communication from buyer, sold and conveyed Greenacre to Citizen for $120,000. On April 21st, owner received a letter from buyer enclosing a cashier's check for $100 payable to owner and stating, "I am hereby exercising my option to purchase Greenacre and am prepared to close whenever you are ready." Which of the following, if proved, best supports buyer's suits against owner for breach of contract? A. Buyer was unaware of the sale to Citizen when owner received the letter and check from buyer on April 21st. B. On April 15th, buyer decided to purchase Greenacre and applied for and obtained a commitment from bank for a $75,000 loan to help finance the project. C. When the April 1st writing was signed, owner said to buyer, "Don't worry about the $100. The recital of $100 to be paid makes this deal binding." Or D. Owner and buyer are both professional dealers in real estate. Take 10 seconds and choose the best option. If you chose option A, buyer was unaware of the sale to Citizen when the owner received the letter and check from buyer on April 21st. Option A, you'd be correct. The rule is that the offeree must have notice of a revocation of an offer in order for the revocation to be effective. The act of making multiple offers does not by itself revoke earlier offers, and if one offeree accepts, the offeror must notify every other offeree to effectively revoke the other offers. In this case, the owner sold Greenacre to Citizen for $120,000, but the owner never informed buyer that his offer of the option to purchase Greenacre for $100,000 within 30 days had been revoked. Therefore, buyer's best argument is that buyer was unaware of the sale to Citizen when owner received the letter and check from buyer on April 21st. Let's move on to question number 8. Plaintiff sued defendant for personal injuries arising out of an automobile accident. Which of the following would be an error? A. The judge allows defendant's attorney to ask defendant questions on cross-examination that go well beyond the scope of direct examination by plaintiff, who has been called as an adverse witness. B. The judge refuses to allow defendant's attorney to cross-examine defendant by leading questions. C. The judge allows cross-examination about the credibility of a witness even though no question relating to credibility has been asked on direct examination. Or D. The judge, despite defendant's request for exclusion of witnesses, allows plaintiff's eyewitness to remain in the courtroom after testifying, even though the witness is expected to be recalled for further cross-examination. Take 10 seconds. If you chose option D, the judge, despite defendant's request for exclusion of witnesses, allows plaintiff's witness to remain in the courtroom after testifying, even though the eyewitness is expected to be recalled for further cross-examination, you'd be correct. The rule is that at a party's request, the court must order witnesses excluded so that they cannot hear other witnesses' testimony, or the court may do so on its own. But this rule does not authorize excluding A. a party who is a party, B. an officer or employee of a party after being designated as the party's representative by its attorney, C. a person whose presence a party shows to be essential to presenting the party's claim or defense, or D. a person authorized by statute to be present. In answer choice D, the defendant requested for exclusion of witnesses, but the judge nevertheless allows plaintiff's witness to remain in the courtroom after testifying, even though the eyewitness is expected to be recalled for further cross-examination. Since plaintiff's eyewitness is not a party or designated officer / employee of a party, a person whose presence is essential to the presentation of a party's case, or a person who is statutorily authorized to be present, the judge must order witnesses excluded from the courtroom upon the defendant's request. As such, the judge's decision in D would be an error. Arguably, A through C would be within the judge's discretion. So as a result, D would be the best option. Question number 9. Art, who owned Blackacre in fee simple, conveyed Blackacre to B by warranty deed. Celia, an adjoining owner, asserted title to Blackacre and bore an appropriate action against B to quiet title to Blackacre. B demanded that Art defend B's title under the deed's covenant of warranty, but Art refused. B then successfully defended at her own expense. B brought an appropriate action against Art to recover B's expenses incurred in defending against Celia's action to quiet title to Blackacre. In this action, the court should decide for A, B, because in effect, it was Art's title that was challenged. B, because Art's deed to her included the covenant of warranty. C, Art, because the title Art conveyed was not defective. Or D, Art, because Celia may elect which of Art or B to sue. Take 10 seconds and choose the best option now. If you chose option C, you'd be correct, Art, because the title Art conveyed was not defective. A general warranty deed contains 6 covenants that warrant against all defects in title. 1, the covenant of season. 2, the covenant of right to convey. 3, the covenant against encumbrances. 4, covenant of quiet enjoyment. 5, covenant of warranty. And 6, covenant of further assurances. These warranties are breached if the grantee is disturbed while in possession. Under the covenant for warranty, grantor warrants that she will defend against lawful claims and that grantor will compensate grantee for any loss that grantee may sustain by assertion of superior title. In this case, Art conveyed Blackacre to B by warranty deed. Subsequently, Celia brought an appropriate action against B to quiet title to Blackacre. The warranty deed requires Art to defend against lawful claims of superior title and compensate B for any loss that B may sustain by assertion of superior title. Art, however, is not responsible for claims of superior title that are made in bad faith. Since B successfully defended against Celia's claims of superior title was not lawful, and as such, the court should decide for Art. Think of it of this way. In essence, once Art conveyed title, the ultimate litigation led to a decision that B's claim was in fact protected against Celia's claim, which in essence is an adverse possession claim. The decision against Celia and for B ultimately confirms that Art in fact transferred proper title. So as a result, he's fully covered. Question number 10. The Rapido is a sports car manufactured by the Rapido Motor Company. The Rapido has an excellent reputation for mechanical reliability, with one exception, that the motor may stall if the engine has not had an extended warm-up. Driver had just begun to drive her Rapido in city traffic without a warm-up when the engine suddenly stalled. A car driven by Trudy rear-ended driver's car. Driver suffered no external physical injuries as a result of the collision. However, the shock of the crash caused her to suffer a severe heart attack. Driver brought an action against the Rapido Motor Company based on strict liability in tort. During the trial, the plaintiff presented evidence of an alternative engine design of equal cost that would have eliminated the stalling problem without impairing the functions of the engine in any way. The defendant moves for a directed verdict at the close of the evidence. The motion should be A, denied because the jury could find that an unreasonably dangerous defect in the engine was a proximate cause of the collision. B, denied if the jury could find that the Rapido was not crash-worthy. C, granted because Trudy's failure to stop within an assured clear distance was a superseding cause of the collision. Or D, granted, if a person of normal sensitivity would not have suffered a heart attack under these circumstances. Take 10 seconds now. The correct answer is A, denied, because the jury could find that an unreasonably dangerous defect in the engine was a proximate cause of the collision. A judge may issue a directed verdict against a party if the judge determines that the burden of proof for that party's issue has not been met. For products liability, the general rule is that the seller of a product is strictly liable for any injuries caused by defective products. A defect in a product can be a manufacturing defect or a design defect. A design defect exists when all of the products are the same and they all bear a feature whose design is itself defective and unreasonably dangerous. To prove a design defect, the plaintiff must show that the defendant could have made a safer product without serious impact to the product's price or utility. Here, Rapido's motor may stall if the engine has not had an extended warm-up. Driver presented evidence of an alternative engine design of equal cost to Rapido's engine that would eliminate the stalling problem without impairing the function of the engine in any way. Driver has met the burden of proof regarding a design defect based on this evidence because all of Rapido's engines suffer from the stalling problem, and this problem is unreasonably dangerous when an alternative engine design of equal cost would have eliminated the problem. As such, Rapido's motion for a directed verdict against Driver should be denied because the jury could find that an unreasonably dangerous defect in the engine was a proximate cause of the collision. As usual, thank you for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. Don't forget to like, subscribe, and click the notification bell so you can be updated every time we upload new content. It's our goal to upload new content every day at 8 a.m. Eastern Standard Time.